Hilary Bricken, welcome to Legally Contented. Please introduce yourself to our audience.
Thanks, Wayne. My name is Hilary Bricken. I'm an attorney. I'm licensed to practice in California, Washington, and Florida. And I'm here today to talk about, I guess it's still the burgeoning practice of cannabis law to a degree, but how I got there and how I market that area.
Yes, and Hilary, you are widely recognized, if not then the preeminent cannabis lawyer in the country. And as we discussed before we hit record, my hunch is that you got there in part because you were very smart and very strategic with your marketing, especially your thought leadership marketing through your Canna Law Blog, through your speaking engagements. And we're going to cover all that in a moment. But I have to know, how did you get started on your path out of the University of Miami School of Law way back, 12, 13 years ago, to where you are today? And by the way, the law firm that you're at right now, Harris Bricken, didn't have Bricken as part of the name when you first started. So that in and of itself is a testament to your prowess and your business development skills. But let's go back to Miami School of Law and those early days of your legal practice. Tell me about how you got to the firm and how you began to get into what was then a burgeoning, even more burgeoning practice of cannabis law.
So back at the University of Miami, what I really wanted to do was be an immigration lawyer. That law school has, I think, a very good entree into the international community, especially with Central and South America. That's what I really wanted to do. However, when I graduated, it was 2 years after the height of the crash in '08, and it was very difficult for lawyers to get jobs. Firms were not hiring, obviously. So I had very few options to pursue the immigration route. My husband, who I'm still married to, was in the military, and he got stationed at Joint Base Lewis McChord right outside of Tacoma in the state of Washington. So I was born and raised in Florida, never really lived on the West Coast, let alone Washington State, which is its own animal. And I decided, what the hell? I have nothing to lose. I have no employment prospects. I'm going to go out there and take the bar. And I did, and I passed it, obviously. But the job prospects were nearly nothing, and I didn't know a soul. So what I started to do was go through the alumni Rolodex from the University of Miami, which also has LLM programs. A single attorney cropped up who had gone to Miami, had Florida in his background, maritime lawyer, and his name was Charles Moray. So when I joined the firm, it was Harris Moray, and I was basically Moray's associate doing maritime law. So I started out as a litigator for the first year and a half of my career. And in addition to maritime, obscurely, I was also doing cases around foreclosing on secured interests. So I would go and repo things. And one of the things that I repoed was a Chihuly chandelier in someone's penthouse who had defaulted on one of our clients' many, many loans. So I had a background that was a little weird. I was pretty much willing to do anything because I had nothing to lose and I had a ton of student debt to pay off. So I was extremely motivated to generate revenue and make a name for myself as a lawyer, and especially in a legal community where, frankly, I was an outsider. Seattle is a very small, competitive legal community. It was very difficult to get in. And because I showed that I had the wherewithal in these kind of weird, very tricky areas, the partners decided that with new and emerging markets, they were going to come to me first. And what they decided to do was give me basically the opportunity to pursue the cannabis practice. But in a nutshell, that's how I wound up at Harris and Moray. And for those listening, don't get down with whatever's happening with the legal market. I nearly took a sales job in the men's department at Macy's at the Tacoma Mall before my law firm hired me as an associate for, get this, $10 an hour. I had to start with that as an independent contractor, and then they hired me as an associate. So things can get really bleak before they get amazing.
And at that sales position, you may have had a life that revolved around cannabis, but in a different manner than blog posts and your legal practice. As a fellow graduate of law school around that time, I graduated in the spring of 2009. And I remember very vividly the emails and the articles coming out about attorneys being deferred, new associates being deferred, or the previous classes being completely laid off. And it was a very turbulent time to be entering the legal practice. I had my big law summer associateship in 2008. And then that became a job that should have started in October '09, got deferred till March 2010 because of the economy. I was fortunate. I only had 6 months of deferment. Some people had a full year. Some people were permanently deferred. And I'm sure as someone who graduated around that time from law school, it must have amazed you, and perhaps as the co-owner of a law firm, the employment market for associates over the past couple of years, obviously it seems to slow down, but the crazy market of 2020, 2021, where you had firms that were backing up almost literally the truck and handing out bags of money to get these
Yeah.
associates to join them, had real interesting ramifications for client service and smaller firms who were losing attorneys to larger firms who wouldn't have previously dared recruit from them, but they were just so desperate to get all hands on deck when it came to these legal matters they needed help with. They went to usual and non-traditional sources for those associates. You hinted that there were some other emerging industries or other emerging areas of law that you may have been dangled into, like Tom Cruise Mission Impossible style, from the ceiling. What were they? And did any of them end up becoming a practice that you stuck with in some small form or fashion?
Our firm, and I think this is kind of the beauty of the boutique, the midsize, is that you're agile, you can move with alacrity, you don't have to go through a ton of bureaucracy if you want to attack a new area and occupy it as an expert, because you can. We don't have to be maybe as careful, and there's less reputational risk, I suppose. I didn't really end up doing anything more than cannabis because it was in such high demand, and notoriously law firms were really not participating at that time on the business and the transactional side. And my work history lent itself to the fact that I could transition from litigation into a more corporate transactional practice, especially because of the secured interest work, obviously. But other areas that we still have today, China was a big area, taking foreigners over, protecting their intellectual property, dealing with Chinese manufacturers, Chinese disputes. That has paid dividends over the years. It is extremely dicey, maybe more arbitrary, potentially dangerous, more dangerous than cannabis from a legal perspective. We also examined the Internet of Things when that was kind of emerging. And now today we do things like Web3 and crypto. Again, not my bag, but we're always looking for the next legal horizon that people are not thinking about. And we're a very entrepreneurial firm. And I think that that sets us aside. And it's also why we're very savvy marketers, which, yes, obviously cuts in to the lawyering and honing your skills, but you have to do it at a firm like ours because we're not going to have a marketing team of legion. So we were always on the lookout for new areas. And the ones that stuck were the ones, I think, that dealt in commodities like cannabis, consumer goods, anything with food, beverage, medical devices, drugs. Those have tended to stick around rather than the others that maybe have failed. Like the Internet of Things never really turned into anything because it was too amorphous.
Were you given a playbook for how to develop the cannabis law practice and how to develop your skills as a cannabis law lawyer? Because it's one thing if you walked into mass tort defense or mass tort prosecution, or you wanted to be an IP attorney or a tax attorney. Those are well-worn paths. You can go to the ABA bookstore, you can go wherever and get books and read and talk to people. But my sense is that you were still relatively early on, and Harris Moray was relatively early on in cannabis becoming a bigger practice. You don't have CLEs. It's just a very different world. So how did you even know what path to go? And oh, by the way, it's not like you were practicing an attorney for decades. You were a relatively junior attorney recently out of law school. So how do you juggle the novelty of this relatively new legal practice?
I would say this area is not for everybody because it's such a fast moving target and because it's not as established. There are a lot of lawyers that don't like having the totem of directions to go by. At the time, I didn't know enough to say no. I didn't really know how big the pain points would be, but as I said, I had absolutely nothing to lose. All I had was a husband, and he was in the military, so he was deployed a lot. So I really had a lot of time to focus and hone. First of all, it was about salesmanship, bringing these people in. And obviously, you can tell I was right about to take a sales job before I nearly couldn't get a legal job. And that's that entrepreneurial spirit of closing people. Even when you don't have the whole story, you want to be helpful and you're motivated. And the good thing about cannabis, the not sexy thing, is that the traditional concepts started to apply right away. Corporate law is corporate law is corporate law. Nonprofit is a nonprofit. The bent was these are federally illegal entities. So exceptions applied all over the place, but the result were issues of first impression. And that's where I, in particular, really shined because there was no playbook. You could literally take these chances with the right caveats, the right CYAing, and make magic. And I don't think that a lot of lawyers get to do that, because it is so very ingrained with case law, customary ways of doing things, and other areas of law. This just wasn't one of those things 10 years ago. And I was very comfortable in that aspect. I never really thought of myself as kind of a legal maverick ever. I was clueless when I graduated from law school. I went K through JD. I was a scholarship soccer player in college, super regimented, don't ask questions, do what they tell you to do. So this was kind of stepping into your power where you've got your legs under you a bit. You understand how the law works generally in practice. And now you're learning how the law works as a business and how to make money as an attorney. And that just motivates the hell out of you to get square really quick. And fortunately for me, I have a lot of common sense. I will say that about myself. And that guided me a lot in how to deal with these clients. And obviously, there were other lawyers in the firm that had expertise in areas that I was starting to really delve into, like securities, corporate formation, transactional work, M&A. And right now, I would say I've become more of a generalist. And sometimes that makes lawyers queasy. But again, at a firm like mine, you're not going to have the luxury of being a dedicated specialist in a super obscure area of the law. You are going to have to wear multiple hats. The benefit for me in looking back is that I knew when to pump the brakes. I knew when I was out over my skis, and that's that common sense kicking in, and would find other professionals to assist these clients. I still think there are lawyers in this particular space that want to be avant-garde, they want to do it all, and sometimes that's with reckless abandon and to the detriment of the client. But I was never one of those people. It never interested me to be the consigliere that knew it all, that was the be-all, end-all. I knew when to pump the brakes, and that really benefited me in my practice.
Were you actually tasked with building the practice in terms of bringing in clients and marketing the practice? Or at the earlier stage, were you just, hey, here's Hilary, she wants to do cannabis law, so you can be the associate tagging along with the partner who's doing
Oh
the
gosh,
real work?
I wish I had a partner at that point. That I did not have that luxury. I was basically thrown into the fire, and the partner said, "If you can make this work, that's great. If you can't, come back to litigation." And we had a comp structure in the firm that associates, and we still have this today, would get a percentage for origination. And in the small firm, you kind of get that luxury off the bat where the partners want you to engage in business development. It benefits them, benefits the firm, benefits you. And I just leaned into that like crazy. And 10 years ago, it was not unusual for me to have an 8 hour, 10 hour day where I was just physically meeting with people hour after hour after hour after hour. And I realized very quickly you had to put the face time in, you had to talk the talk, let alone deliver on results, but you had to be very persuasive in your pitch. And lawyers can be really bad at that because they want to qualify everything. They want to condition everything. You cannot do that with client sales. You have to be somewhat definitive, speak with confidence. And I learned very quickly that that was the road to client development. No partner was helping me do that. That was fairly innate. And I did have a springboard in that the way the practice developed with us was that at the outset, a criminal defense lawyer with a very big book of defense clients, mainly medical marijuana clients at that point, came to us and said, "These people are starting to ask me about business concepts. I have no desire and I don't have the time to become competent in that area. I want to keep doing criminal litigation." And he would send those people to us every now and then. But very quickly, and because Washington is a small state, Seattle is a small, big little city, my name just exploded as one lawyer that was willing to do this relatively sophisticated ish work to turn away from the dark side, the criminal side of cannabis, and to bring them into the light, get them to start taking on investors, get them to start paying their taxes, getting to them to start paying attention to the regulatory. Nobody was doing that. Lawyers were terrified that they would be implicated for violating the Controlled Substances Act, aiding, abetting, and conspiracy. But again, when you're young, dumb, nothing to lose, and broke, it's just one of those moments like in the movies where you get it and you're going to go for it and you're either going to fail miserably or you're just going to rise. And I was lucky enough to do the latter, but it took an immense amount of work. And it was mainly me.
There's a little bit of a luck here too, in terms of you going to a law firm that had that entrepreneurial culture in two ways. One, to see the future, or at least to see around corners and think that this cannabis law practice was worth exploring, but also, nothing personal, to trust a relatively new attorney to go out there
Yeah.
And you showed them something. There was something that you showed them early on that made them trust you and gave them comfort that they can trust you to do this. But then they trusted a relatively new attorney to go out and market and build this practice. The name of your law firm now bears your name. So I guess that worked out. But it's just fascinating, too, that so often you've got law firms with cultures where that's not going to happen. Even
Right.
small boutique firms, the associates are there to grind away, to build the hours, to bring in the revenue for the partners. Maybe they're leveraged 1, 2, 3, 4 associates per partner. And that's how they make money. And it's a shame because there are entrepreneurial attorneys out there. Many of them get the entrepreneurship beaten out of them because when it's a question of 2,000 hours and a bonus to help pay down your law school loans and your mortgage, and maybe you've got kids or on the way, so you've got those expenses, when you do that short-term money versus the long-term promise of entrepreneurship, sometimes the short-term thinking wins out because that's just the way life is and the way humans react. A lot of it, I think, is being fortunate to be in a position where you had the right skill set, but you also found the right firm. And there's so many attorneys, and perhaps they come crying to you. There are so many attorneys who have a skill set that could be entrepreneurial if it was wound up and put in the right direction, but it's not because they're at a firm that sees them as a cog in the billable hour wheel, in the billable matter wheel, and they just go off and they bill.
That's right. Law firms and their structures are interesting and mostly sad at the end of the day. And in this firm, and one partner in particular, the Harris, always been very entrepreneurial, thinks differently, doesn't think like a lawyer, and he started his litigation career at Kirkland and Ellis. So the guy can lawyer. We're not talking about shameless salespeople who can't actually do the work. We were fortunate enough to meet each other and collaborate together. And I think when the partners gave this to me at the outset, they probably thought it was a joke, that this nobody from the Southeast who's totally new to this legal market, she's not gonna hurt herself or hurt us. Let us just let her try. And when I started to just close people mercilessly and the dollars started rolling in, that changed the tone of the conversation. And I did not have to go back to litigation. I was allowed to basically have my own associates because we were growing in such stature and it was my baby. And the timing has to be right. To your point, Wayne, if you have kids, you have a spouse, you have a life on the side, you're not going to be spending 20 hours a day incubating these great entrepreneurial legal ideas. It's just nearly impossible. And now I do have 2 kids and a very full life, and I don't have to do those hands in the dirt type things anymore. But I'm so glad I got the opportunity that I did. And frankly, I'll be very honest. I wasn't eligible for a big law position. I was a very mediocre law student. I didn't know how to study, and Miami is a super distraction. So I really thought that my legal career was headed for the trash. I thought, I'll do great as a litigation associate at a small firm, and I'll be the cog. But I think that trust came from giving me projects, finishing them soup to nuts, engaging in client management, and being very focused on revenue to the point where I was already acting like a partner. I just kind of didn't know it, where I'm being tough on clients to collect. I'm being innovative about projects. I'm staffing projects myself. I just got that opportunity very, very early in my career. Maybe too early, to be honest. I think I was in for like a year and a half.
That seems to be the trade-off when you go big law versus boutique. When 6.5 years as an associate at one of the largest law firms in the country or the world, I took maybe 3 depositions and they were all pro bono depositions. Meanwhile, someone who's probably making a third to a half of what I was making out of law school probably had 3 depositions their first month if they went to a small enough firm. So it's interesting how you have the trade-offs with the experiences and the client-facing work. Some people have to go out there and start networking immediately because they are expected to bring in business, whereas most big law associates are expected to just start billing immediately and don't pick your head up until 10 years down the road. We'll let you know if you'll be a partner here, if you can just say goodbye in 90 days. I want to get into how you conducted the marketing and business development that got you to bring in these clients and elevate your stature and the firm stature. But I'm curious, before we go there, did you have any concerns as a young associate that you specializing in cannabis law could reflect poorly upon you based on the very stodgy, buttoned up sensibilities that most lawyers have, that somehow Hilary doing this work, even if it is fantastic work and the work is legal based on the state laws that these clients have to abide by, but still you're doing marijuana. Call it cannabis. It's weed, dude. It's marijuana. Did you have that issue or that concern?
I definitely had that concern. I was definitely concerned with reputational risk. I mean, I was brand spanking new out of law school, and I jump in to the weeds with a bunch of drug dealers. And some of these people were terrifying. I would literally talk to anybody, and I could tell you crazy anecdotes about what I did during my course of work in those first few years. Sometimes I miss it. Other times I'm like, I can't believe I did that. I do think still certain lawyers probably think I'm a joke when they hear marijuana lawyer or weed lawyer because it's federally illegal. It has a certain element of illegitimacy, and certainly there are screwballs in this industry. Sometimes I think everybody that worked at Theranos or that did Firefest lateraled into cannabis, to be honest with you. So absolutely, I had that concern. And then on the ethical side and the legal side, the lawyers do have liability. You know, a zealous prosecutor could say you're aiding and abetting, you're the consigliere, you're just as guilty as the person planting it and distributing it. That's the drug dealer. And then with the ethical implications at the outset, there were no accommodations for this weird ambiguity where states decided to opt out of federal prohibition, and these people needed help, and the regulators wanted them to have attorneys to guide them to make the democratic experiments a success. So you even take a risk in that regard. And early on, I did get a bar complaint, and it wasn't even from a client. This was in the state of Washington. You know, in Washington, you have to check the box for who you are as the complainant, and it said client, former client. I thought, who the hell would bring this against me? I've been practicing for like 30 seconds. I go down to the bottom, the guy checked the box, and it said activist. I thought, okay, here we go. And what he wrote to the bar was that they should strip me of my license because I was openly helping people violate the law by getting them licenses, setting up their businesses, and telling them to pay taxes. I thought, this is ludicrous. This guy's a gadfly. He wants it to stay underground. So, of course, he's going after the lawyers. You know, not a bad tactic. I thought the bar would dismiss it out of hand. They did not. It took about 9 months to get through that complaint where they really had to consider, was I unethical just by virtue of practicing in the industry? And they determined, not that I was innocent, but that there was insufficient evidence of unethical conduct. So I could keep going within this limited capacity of helping people comply with the law. That was 12 years ago. Now, today, we have full bar rules that are revised by the Supreme Courts of the states to allow for this very practice. So yes, I had and still have reputational risk concerns. I'm less concerned about the ethics. And if a prosecutor comes after me, you know, we got bigger problems than the war in Russia because that's pretty low hanging fruit. I do not foresee that happening.
So we get over these hurdles. Your practice is on the rise. Tell me about the business development and the marketing efforts that you undertook. Obviously, this is going toward the Canna Law Blog and the idea that thought leadership and content marketing were going to be key here. But what was the path to your blogging? And did you try any other tactics or strategies to supplement your business development and marketing efforts?
So in the beginning, same as everybody else, I just pounded the pavement. I showed up at every single event, typically had a speaking engagement, got close with the regulators, became kind of an outside confidant of sorts for certain stakeholders in the industry, basically lobbying without even knowing it. And then to make it easier, faster, or consolidate it, the blog started in 2012 and it was just me. And I did that because my partner, the Harris, he's a big China lawyer, and he has the China Law Blog, and he's saying its praises about how it would generate clientele and interest, and it would. That blog still pays dividends today. So I basically followed the same blueprint. And like I said, Harris is very entrepreneurial. He was basically my mentor. So I ripped a page out of his book and I said, well, I'm just going to do the Canna Law Blog. And I would blog maybe once or twice a week. Nothing that would generate anything positive. That's obviously not enough. But as I began to become more knowledgeable in the area, especially on the regulatory piece, and once Washington legalized, which changed the game in 2012, the content was endless. So I found myself in my marketing efforts doing less FaceTime, less academic articles, less publications for trade journals and magazines, and really focusing on the quality of the blog. That thing is a beast. And our SEO is incredible because we started so very early, probably one of the biggest assets in the law firm that started essentially from nothing. And when it did start, it was so hokey and covered in pot leaves and looked insane. And now, it's a very legitimate legal blog that's won multiple awards, and I'm really proud of it. And it's multi-author, so I don't have to sweat it all the time. But it was a labor of love, and it began because it was the fastest, most efficient way, it probably still is, to get content to potential clients, regulators, stakeholders, and show professionalism and legitimacy.
Where were you getting the information that fueled your posts that early on when the practice was still young? You didn't have cannabis beat reporters, or maybe you didn't have as many. You weren't going to have, as you mentioned, Washington State hadn't legalized it yet, so maybe there wasn't as much traditional media. Where are you pulling from in those early days? And then today, what is your process? You mentioned multiple authors. What is your process today for managing those multiple streams of cannabis related content that provides the basis for your blog posts today?
In the beginning, it was mostly firsthand experience, what I was seeing with my clients, and then these common issues that would crop up in their representation, like tax impact, other federal conflict issues, trademark issues that they were all experiencing at the same time, lack of regulation, future legislation, super elementary stuff. And then as the years went on and we acquired more authors, and of course, as the feds began to participate, give us guidance, and legislation began popping off in multiple states through voter initiatives, other people began to participate that had interest in those other areas like trademark, supply agreements, distribution agreements that they specialized in and their other practice areas. So as I think the content began to grow, because more states began to opt in, or for example, in Washington, once we had legalization, then we really had a roadmap for multiple issues about which to write that weren't just newsy pieces. I mean, this was us really practicing law and not being afraid in our content to say, this is really how you do a thing. And it's not a sales pitch, right? Just enough to say, here's the danger, and to illuminate that for whomever would read it. And, we didn't really care if we got hired. It was more interesting to share the content. And then that generated goodwill with media and obviously with regulators. Now, today, with the multiple authors, we basically tell people, it's me and another lawyer in my firm that are the editors, write about what interests you. If it's newsy or splashy or punchy or even outside your area, we really don't care. We want you to write about it with fervor and write it well, because you just never know. And just by way of example, it's not like I'm some web attorney that does terms and conditions or privacy or data or any of that stuff. I wrote a blog post about how Google is changing its advertising operational rules for the sale of cannabis products, including a compound called cannabidiol, CBD, very popular. No kidding. A day later, a massive, massive third party payment processing company contacted me because they had read the blog post and they said, what should we be doing? We don't do ads, but we do payment processing. They're just as culpable for helping in those transactions by moving the money as Google is for running the ads. So you just never know. If you write about stuff that interests you, it's going to yield fruit at some point. And that's kind of the directive today. It's less desperate. It's less, I think, hackneyed, in that we're beyond the basics of this area and way more nuanced into what interests people, international movements, thinking more globally. That's kind of the message.
How do you balance the newsy type analysis versus the true thought leadership analysis? Because you see this all the time, especially at larger law firms, when, let's use a recent example, the FTC announces that it is contemplating ending or banning non-compete clauses. And the race was on for all of these law firms to, as soon as possible, get out into their clients' inboxes, email inboxes, client alerts that almost entirely regurgitated the FTC's announcement with no analysis because they didn't have time. The FTC makes their announcement on day one, and then day one plus 6 hours later, the client alert is out, versus the law firm that took a step back and said, we've got a lot of clients in the healthcare space. We have a lot of clients in the tech space. Let's wait 3-4 days. And now the client alert is more about what should you, as a tech company, as a healthcare company, be thinking about considering the FTC's proposed end of non-competes? So there is some value for the news alert style, I think, especially if you're a boutique employment firm, where even the mere proposed legislation could have an impact on your clients when it comes to wage and hour laws. So you want to get that out there. But I'm curious, how do you balance? Because if you are the true source of legal analysis and insights from a cannabis law perspective, then so much of that is reacting to state legislatures, government agencies, perhaps applicable case law coming down. But then we all know that the thought leadership, the kind of bigger picture reviewing and analyzing, is what often sets you apart, because that is unique to you and your colleagues. So how do you balance those two factors?
We've stopped being so generous with the breaking news events because there's almost breaking news every other week, and there's not enough time to earnestly write about it or digest it. And some of it we don't even do, like things related to employment with the NLRB or OSHA that may impact cannabis companies, or hardcore securities work. We're not writing about NYSE or NASDAQ listings all the time. We try to be very thoughtful, and I'd say it's probably 30-70 on regurgitative, splashy breaking news. Look, we're a first mover. We've been watching it. We know what's happening. I'd say at this point we've built up so much gravitas that people know that we're watching, and that when we put something out there, it's going to have enough analysis to make you think. Not necessarily about hiring a lawyer, but about what your next move is. And oftentimes that includes strategic legal thinking or business directives that you may not have considered. So, another example is in cannabis, many people, including reporters, are writing about this impending recession or it's already here for cannabis and growers are dying. No one had said this is how you prepare for it. This is what you do when you're in this situation legally. Review your contracts, review your workforce, make sure that you're not violating, wage and hour law. Reduce your legal spend. Here's how you do that. This is what's important within the legal realm. I even did it with Chat GPT, the chatbot. I did an interview with it. Am I going to get replaced as your cannabis lawyer? Because everyone's talking about it, and it wasn't just here's my interview. This thing is scary good. It was to break down what it was really saying about ethics, whether that was complete, was it nuanced, could it draft a contract? Obviously not. And trying to be more functional and helpful than just informative. That's really our goal. So we are really more and more trying to avoid the newsiness of things that ends up being meaningless if it's just over and over repeated without analysis. We don't want to engage in that.
There's an interesting dynamic here too. You, over time, in terms of being of service to prospective clients, current clients, referral sources, the industry, with this free source of insights and guidance, you've developed trust in the audience has developed trust in you and your colleagues in this Canna Law Blog, because they come to you, they look to you and your colleagues for insights and guidance. You are almost violating that trust if you give them the clickbaity crap that they can get anywhere else, right? Like, they are coming to you because you know stuff. And the way you communicate that in this form is to create interesting tidbits or interesting blog posts that cover that stuff and that makes that industry participant, that client or referral source go, yeah, she still has it. These guys still have it because this is a great analysis that I'm not finding anywhere else, because no one else has that kind of foothold in the industry and knows what Harris Bricken lawyers know about the cannabis law world.
You got to listen to your readership. And once you get really good, your readership is going to get very vocal. And that's actually helpful to you. We take all critiques, criticisms, positive comments, and digest it and say, what should we be doing better? What should we not do? And another example, psychedelics are blowing up, right? Everybody knows about psilocybin this and MDMA that, or ketamine this. And we have a piece of that within the firm because it's part of that emerging area that really is new drug development and health and wellness. It's right up our alley. And we tried to put some psychedelics law posts on the Canna Law Blog. Canna Law Blog readership did not want that. They do not like that. They wanted all cannabis all the time. Do not distract me with your other practice areas. So now we have a psychedelics law blog specifically for that. But if you're just writing to write and to be a first mover and say, hey, look, we were on this, we thought about it for 30 seconds, I think it actually might hurt you, unless you're brand name big law, and then it's unquestionable, right, that you've got the best working behind you. But for everybody else, I think if you're going to do it, you need to do it well. It's got to be thoughtful. And it's got to be something that's going to make readers go, wow, I didn't even consider that. Not just the news. They can read that pretty much anywhere from any layperson. There's no value in that.
How did you manage the delicate dance of transitioning the Canna Law Blog from your kind of purview, almost exclusive purview, and creating the systems and processes that allow you to bring in your colleagues, your associates? Because so often blogging starts as a personal endeavor by one attorney or maybe two attorneys, and then hopefully it pays off and they get busy and they have to begin to spread the love. How do you handle building the processes and systems that allow the Canna Law Blog to run smoothly, but from the perspective of getting more contributors and the researching or the editing and the publishing? How's it all work? And what was that dance like for you in terms of going smoothly or with some hiccups on the way?
I mean, I was very welcoming to having additional authors, and my pitch was, look, you write and things will come. It was like Field of Dreams. And I was very clear in the beginning, do not write me a sales pitch or you will be dead. That's not going to make the cut. And don't even think about hiring a ghostwriter. It's going to come from you and your firsthand experience. And what was most persuasive was not my idle threat of murder. It was that people could raise their own visibility very quickly because you were writing about interesting things. And we did have a first mover advantage. There was no other blog like that out there. Nothing, nowhere, not from any firm of any size. They weren't writing about it unless it was from a criminal perspective. So this was a huge opportunity for people willing to take it and do it well. And I'd say part of the management that's the hard part is when maybe we don't have that strong of a writer that doesn't understand the style of the Canna Law Blog. The other important thing about attracting other people to write for it, we're very clear. It's not a law review article. It's the absolute opposite of a law review article. And if you're getting analysis paralysis, you need to take a step back. And there are people at my firm that don't blog, that practice in the area, but it's not their strong suit, and that's okay. Not everybody has to do it. It was for the willing and able that had interest, that wanted to raise their profile, either with media, regulators, their own clients, or frankly within the firm as somebody that would know and master the area.
Did you then have to build a process where you've got someone is assigned the blog post or they raise their hand and then it goes to someone to review it and edit it and then it goes to you for final sign off? What is that process?
Eventually, because it was getting overwhelming and we really only had a handful of people writing, we made it a condition of employment. So our law firm is pretty strange. When you get hired, part of your compensation is based on your marketing and what you're doing and how you're doing it. And you can write a certain number of blog posts and get a bonus, or fail to write at all and suffer the consequences. And then within the team that handles cannabis, from litigation to IP to transactional to taxes, corporate, whatever, basically their expectation is not that everybody gets a set day. We tried that. It didn't work. It was too much pressure for people, and people's schedules went up and down. They were all over the place. Now the expectation is just get us the volume. We don't care when you do it, right? And if we have to have a call to action to generate posts, we do that, and people are responsive because they know it affects their comp. So at the big firm, that's probably never going to happen ever. But to me, somebody like me, if I was presented with that, I would say, hell yeah, this is something I can easily meet. It's not a law review article. It's supposed to be for lay people, something I care about and I'm interested in, and I don't have to get up on stage and talk to people. I'm going to choose blogging. My hope is that that's a motivator for people who want to write, but maybe not academically, but in a very meaningful way. So that's how we motivate. That's how we organize. It's been successful. And the thing is, it's more than just the money. I think with enough authorship, people realize they begin to become this authority, and it's bigger than just what hits your bank account for your bonus. It's really, that blog has generated amazing goodwill with lead academics, really important regulators in various states, law enforcement, and overall the legal community, where the referral network is just sterling. That's bigger and better than a small bonus, based on writing. And people are beginning to understand that, especially our younger attorneys.
Has anyone to date, any prospective associates, read those terms and said, oh, I think I'm going to pass on this firm?
Nope, we haven't had anybody do that. We did have a couple of employees that forgot that this was a condition of employment, and they got worked up, and then they calmed down. And we're very generous. It's a quarter by quarter thing. You can catch up actually and help yourself. We have others that go, I don't care, not going to write. I'll take the hit. That's fine. That's totally fine. It's at their option, but the firm needs it because, like I said, we don't have marketing legion, and it is on us. And that's why the content is outstanding because it's coming from the lawyers themselves, not a copywriter, not a ghostwriter, not a professional writer. It's the lawyers in the trenches reporting on things that actually impact our clients. And sometimes we'll even get a client to allow us to disclose who they are and write about their individual matters, and that's been interesting. And I think our attorneys, they like that dynamic to be able to share that about clients because it raises the client's profile in varying degrees. So no one's run from it. People have forgotten about it, but nobody's quit over it or anything.
I also think, too, you are in a way doing these associates a favor by introducing very early on the value of business development and marketing and the idea that it can flow seamlessly as a lawyer, and arguably it should flow seamlessly as a lawyer side by side with your client facing work because, and you're entrepreneurial. I would like to think I'm entrepreneurial. The attorneys who are entrepreneurial soon realize that if they want to truly be entrepreneurs and have the autonomy that they crave to build what they want to build, they need to have their own book of business. They can't live off a rainmaker's book of business because they are chained to that rainmaker, which means they're probably chained to their computer and their desk.
Exactly. And I do think that that's the benefit that a firm like mine might have over Big Law for those particular individuals is that we are going to give you the opportunity, we're going to give you the chance, and we're not afraid to do that, and we encourage it. And of course, we have lawyers that they'd rather sit behind the desk. They don't want to do any marketing. They love the law. They just want to practice, and that's fine too. But our firm is built to make those rainmakers. And I really benefited from that personally. Some of my entrepreneurialism is just innate. It's just the way I roll. And we're going to have people that try, maybe they're not as talented or into it, but they're going to get some very good reps and they're not going to have to rely on other people to basically provide their relevance or justify their existence at the firm, especially when times get lean, like right now. The people with the books are going to survive. And the ones that don't have it are probably expendable to a degree. So I would encourage the grinders, to do more exploration of marketing. It's for your own benefit. I know it hurts, but you can't ignore it in the law if you want to make money and be independent.
A lot of attorneys and law firms view thought leadership and content marketing as a magnet for clients and referral sources, but it can be a recruiting tool. Have you had associates or partners find you or otherwise express an interest in joining your firm based on them understanding that the Canna Law Blog has established you all as leaders in the field?
Oh, yes. I've had multiple people, lateral level hires and associates, new grads, want to join the firm because of our profile and our visibility. They love our entrepreneurship, and they want to be a part of that because they want to create something, right? That's the entrepreneur's main goal is that they want to create and design their own world and be in control. And those are the kinds of people that we tend to attract. And I know because I'm in LA that it's tough to get those big law associates to convert. Some of them are convertible in that these are excellent attorneys, but they have no chops, right, with the marketing, and it makes them a little nervous. But I've had at least one or two come over that have realized the power in building their own book, and now they swear by it. They're like total converts. It's like a cult. And they will tell other associates about it. And obviously, we still get the cringe from the people that are like, oh, I not want to do that. It's too much work. It's such a headache. But overall, the people that contact, at least me, definitely have an interest in the blogging, raising their profile, building their own book, and entering what is still somewhat of an emerging space, but being at a firm that can tap into those emerging markets, leverage its marketing capabilities, and just attack relentlessly. I think that's what we're really good at. And people would say, aren't you busy marketing more than you are practicing law? And these days, I would say, not as much because I have others that are doing it and I want to raise them up. I have a pretty good visible profile, and it's not like I sit on my hands. I still market a lot, but not like I did in the early days. But I do think that the young attorneys, they should have a taste of that and what that feels like to really client develop, really business develop. Um, unless they want, like you said, and your metaphor, a life chain to the desk. I don't think, even if I would have been capable and eligible for that, I don't know how long I would have lasted in that environment before my real personality would have come out.
There are fantastic sensations throughout life, but a great sensation is the first time you have a client hire you to provide you a professional service, and you take a step back and you go, holy crap, that was awesome. And then when they give you the check, it's even better. But just that feeling of something about what you can provide them and that interpersonal connection that you had in order to get to that point has compelled them to want to hire you. Once you have that feeling, I'd say it's addicting. You want to keep on closing those clients. It's a fun feeling to have.
Pretty much. It is like a drug. And I do recall when that happened to me the first time. And it was the first time I ever had a live pitch. And the potential client said, well, why should I go with you? And I said, well, if you go with me, I'll keep you out of jail because you're going to do things right. You don't go with me, you probably wind up in prison in a year. That was a total oversell, completely bluffing. And he wanted to write me a $5,000 check right there on the conference table. And I got out of that meeting and I just went, whoa, that was amazing. And as you said, you just want to keep replicating it because you feel high value add in that moment. They are coming to you, specifically you, not the partner, not anybody else, to you. And that kind of ownership is very unique. It's just a very unique setting. And I was in Girl Scouts and did all these other things. So, I've sold stuff before, cookies, whatever, hostessing at restaurants, delivered customer service. This is different because it's from a very unique perspective as a lawyer in a very exciting area. It could be any area though. And you really, I think, get to feel powerful in that moment. And that's when you start building that confidence, frankly, that you need for the practice of law, no matter what you're doing. So it's a very healthy exercise, in my opinion.
And the confidence to keep moving forward through your entrepreneurial endeavor, whether it's a law firm, a restaurant, another kind of business. There are days where you are riding high because you just said something that closed 3 clients today and you're feeling great. And then you have another day where someone quits on you or you get a nasty email from someone and you had to down part of the roller coaster. So you want to go back up and down. Do you remember way back a decade plus, do you remember the first instance that this blog that you were working on seemed to be generating some traction and could be of value? Did you get a phone call? Did someone refer to it when they contacted you? What was that first? Oh my goodness, someone's reading this.
When I knew it was super powerful was when I was at a live speaking engagement, actually in Spokane of all places. I know people are thinking, oh my God, who cares? But in Washington, it was important because Spokane was a big cannabis market. And I got invited to speak alongside one of the top regulators at the Washington State Liquor and Cannabis Board. And you have to be mindful at this point, nobody had access to these people. Nobody. Because it was one of the first experiments like this in the country. So I'm on stage with a big dog in the body that makes the rules, that holds the fate of my clients. And we had a very conversational presentation. I think an entrepreneur was there that was going to be a grower at the outset of licensing. And he looked out at the crowd. The regulator looked out at the crowd. I had done a blog post on the top 10 red flags in the cannabis industry, right? Anybody could read it, absorb it in any state, frankly, any country, and it probably would apply to a degree. And he told the crowd, if you are not reading her blog, and in particular, this blog post about these top 10 red flags in the industry, you're doing it wrong. And I was floored.
Wow.
Because I basically just got the endorsement of the top dog regulator in Washington for this extremely unique, sexy experiment that was exclusive to our state. That was huge to have a rulemaker say, she's got the roadmap for what the problems are in the industry. That was huge.
Do you remember how early on that was?
Not early. Took a long time. That was probably 2015, 2016, maybe 2014 at the very earliest. So we've been writing
3 years.
Yeah.
How much time and effort do you all spend repurposing the content that you create for the blog, whether that is compiling it and putting it into longer form pieces, whether it is forming the basis for your webinars? Because I would think that it's tempting to let the blog do all of the heavy lifting in terms of the marketing and the business development, but there are, I would imagine, some instances where you could use that content. You already created it. You could use that content to further your business development and marketing efforts. Do you do that, and in what forms?
We do. We probably repurpose maybe half of the time, and we'll do webinars with it. We'll do public speaking engagements about it. We'll do email campaigns. We'll resurface things that have gone on or that have been visited again and again, especially like proposed federal legislation. We'll keep a tracker that people can kind of watch. That's probably the full extent of it outside of academic publications where like Law 360 will contact me and say, we saw you wrote about this thing and we love it and we want you to do it for us. And I'll repurpose, what I've written for them. One example was I wrote hypothetically about what the space would look like if there was government-owned cannabis and what policy issues it would eliminate, like high rates of consumption, youth access, and they loved that. So I repurposed that for them. They have no issue with that. I used to be a columnist for Above the Law for a while, and I would repurpose my content for them. So it's valuable for things like that. But otherwise, we're trying to pump out new content as we see fit, as is relevant. Right now, it's a little bit difficult because the industry is consolidating. There's a little bit of stagnation. So we have to get kind of creative. And certainly we don't blog every day. We used to. We now take the weekends off. So that's helped with content generation. But mostly it's probably 50-50 on repurposing and new content.
Can you talk about the impact of the blog and the other thought leadership you do on the face-to-face communications and networking you have with prospective clients and referral sources? Because I tell my clients that thought leadership and content marketing is the air support for the business development ground game, that people still want to know who they're hiring. They still want to meet their attorneys and referral sources. But with the content marketing and thought leadership, you can, if nothing else, impress people at scale. You can build credibility and trust at scale because you are showing your knowledge off. And then when they meet you, they get a good vibe from you and you can close the deal because you've got the two halves. Do you see that play out for your efforts and in your colleagues' efforts?
Oh, yes. We'll get people that specifically email the authors of a post to say, I saw you wrote about this, and I particularly have this issue. Can we talk? That's probably the most standard one. Then we'll get the more cantankerous person that says, I saw you wrote about this, and I don't agree with it. And you try to turn that right into a sale, depending on what they have going on. Or, in person. Probably less so now post-pandemic, but you'll get people that say, I want to know about this. What does your firm do about this? And literally in an email, you can link to your knowledge base, right? And that's the important thing, at least for me, when I've done my pitching, you have to demonstrate some kind of knowledge and expertise, right? Within the pattern that the potential client is giving you to show that you have value. Without that, they'll never hire you. And without that in the form of a blog post or something in written format or something they can go to, equally, they'll probably never hire you. So I use it all the time. And especially for those inquiries where I've seen it 1,000 times, I don't have to give the pitch on the phone and waste my time. I can vet them out very easily. I send them a link to the post. They'll digest it and come back to me, or they won't. And then I won't have wasted my time on an in-person pitch.
That's great. Content as a filtering mechanism on top of a recruiting mechanism, a business development and marketing mechanism. Yeah, there's no end. And what's funny too is that there are still lawyers out there, not surprisingly, that look at thought leadership as this nice to have. They don't need it. It's not a core part of their marketing and BD efforts, despite the fact that their competitors are well developed in their thought leadership strategy, and the fact that these attorneys themselves, when they're making a decision about anything, whether it's something to buy off of Amazon or an accountant to hire or a contractor to hire for a renovation at their home, they look at their websites, they look at the content, they look at what people are publishing about their trade, their service. The fact that these attorneys think that they can do that in their personal lives, but that general counsel at Fortune 500 or 1,000 or investors or any other person who could hire a corporate law firm wouldn't be doing that in the course of their vetting is just hilarious. As we begin to wrap up, you've obviously relied on thought leadership and content marketing to build your practice, to build your firm, to train colleagues, to give younger associates a chance to build their marketing chops and their business development chops. I'm curious if you can give your tips to those in-house law firm marketers who are on the sidelines about launching a blog for a particular practice, as well as the attorneys themselves and who might be on the sidelines. What would you tell both in-house marketers and attorneys about blogging, whether it is motivation, whether it's the mechanism, how to do it. Just give us some guidance based on your decade plus of building a blog that has powered your marketing and BD efforts.
I really think it's super simple, and it's been repeated before when I hear very intelligent marketers speak, whether they're lawyers or lay people. Just do it. Just do it. It doesn't have to be perfect. Get it going and then retool it and tune it. Had I not just done it, someone would have beat me to it. And the fact that I just put something out there started the motivation to do it again and make it better and bring in bodies to support it. If you are sitting on the sidelines trying to contemplate the perfect vehicle, the perfect title, thinking at every little turn what your readership might want, it's a total waste of time. You just have to do it. And so many people are paralyzed by even that. They think it's this huge lift. It doesn't have to be. Sorry to break it to lawyers. Lawyers know this with each other, and you know this, Wayne. No one cares if you were on law review. Most people don't even know what that is. And even if they do, they can't read what you wrote if they're going to hire you, right? Unless it's in-house counsel. And even then, they're like, I don't have time for this. So just do it and reform from there, right? Ask for forgiveness later. That would be my number one message to people who are contemplating it. And then obviously with blogging, there's so much more than blogging. To me, blogging is just the baseline. Getting into a podcast, right? Doing internal webinars. All those things stem from the blog, because the blog is the thing that has the static content and is building your web presence. It will birth other ideas. So just do it. Let it lead you to a degree and keep an open mind. I still, to your point about these lawyers who are like, oh, nobody would ever check Google to find me or whatever. Yeah, that's ludicrous. But also, don't think anything is too off limits. Seriously. There are even people now that think that blogging is kind of antiquated and has been thing. I don't think that's the case, obviously, especially for attorneys. But keep an open mind with marketing. I think law firm marketing is really hard. I think it's very difficult. It's not like selling a commodity. It's not like selling fashion. It's a balance of things, and lawyers are generally pretty bad at it. So keep an open mind.
And if you think blogging is too difficult to pull off and too much of a heavy lift, go on TikTok and see the attorneys who are banging out videos, especially the plaintiffs facing and the direct-to-consumer facing attorneys, where they are either detailing legal issues for PI attorneys. There are women immigration attorneys who are putting on makeup as they're talking about their immigration cases in an ethical way, but still, like, they are doing things that are native to the platform, like putting on makeup, like dancing, like doing skits. If you think blogging is a heavy lift, go check out the multimedia things that younger attorneys are doing and then get back to us about blogging being a heavy lift.
God, yeah. See, I'm not there. I'm not on the TikTok yet because I'm not going to lip sync to anything and actually be useful, but maybe a podcast coming soon, because blogging has really motivated me, to be honest with you. And I think that's a really good format. Don't know about the TikTok, but keep an open mind.
TikTok now, especially the legal space, has moved past the somewhat humiliating lip sync videos to attorneys who are talking with a green screen behind them. And on the green screen, they put a news article about some legal development, and they talk about that legal development and what it means for the person and what you as the viewer could do to avoid being sued for defamation or being sued for theft or whatever. It's a fascinating, very quickly evolving space, and stay tuned for what Harris Bricken will be doing on various multimedia channels outside of blogging. Hilary, how can people get in contact with you if they want to learn more about the firm, about the Canna Law Blog, or about you personally? Where can we send them?
So you can start with our law firm website. It's harrisbricken.com. Go to our team, go down to Hilary Bricken. You'll find my page. My firm email is on there. And if you don't want to do that, the short form is hilary@harrisbricken.com. And that's 1L. I'm also on Twitter. I'm pretty active on Twitter. Really like Twitter for the consumption of information. Good place for lawyers to build media contacts too. And my handle, shamefully, and I did do this 12 years ago, so forgive me, is cannabis-related. Lawyer. That's about the only hokey marijuana-oriented marketing I have left in my system.
In the scheme of hokiness, that is on the low hokey meter.
Good.
I think it's effective. I think it says what is true. And that's that. It doesn't get into too many crazy symbols and numbers there. So Hilary, thank you so much for taking time to chat with us and to talk about your insights, how a blog and content marketing and thought leadership marketing can build a practice, and how people actually read these things and pay attention to them and actually hire lawyers based on the content provided. So thank you for being so generous with your time today.
You're so very welcome. It was my pleasure.